Well, I think Ireland could learn quite a bit. In the United States, we started seeing mental health exceptions in abortion laws starting in 1967 in California and later 12 other states. The California law was called the Therapeutic Abortion Act. And this law, like its similar laws in other states, allowed abortion to preserve the mother's life or physical or mental health. It also allowed abortions in cases of rape and incest. Unlike the other state laws that were similar to California's, it did not allow abortion for reasons of genetic anomaly. What's interesting about the California experience is that unlike every other state law that opened up broader exceptions for abortion along these lines, California actually tried to define what it would mean to have an abortion for mental health reasons. This was a unique feature peculiar to California law. And the legislature adopted the standard for civil commitment. In other words, a woman could get an abortion for mental health reasons in California if and only if she suffered from a mental illness to the extent that she was a danger to herself or to others or the property of others, or was otherwise in need of supervision or restraint. This is a very rigorous standard. So one would think, without knowing what the subsequent experience was of administering this law, that there would be very few mental health abortions. That, however, did not prove to be the case. In 1970, now this is 2 years before Roe versus Wade was decided, more than 2 years, there were more than 60,000 abortions that were performed in California, over 98% of which were done for reasons of mental health. Very few abortions were done for any other reasons. And under the law, you had to have the unanimous consent of a panel of physicians attesting to the fact that she would, in effect, meet the definition of civil commitment. The California Supreme Court looked at this evidence in 1972, and they said, pregnancy is a normal human condition. It is preposterous to suggest that tens of thousands of women who became pregnant were somehow a danger to themselves or to others. The court struck down the law on other grounds that it had been vaguely drafted. But the important thing to take away from this is that even with a very narrow definition of mental health or mental health exception, and even with the requirement of the unanimous consent of a panel of physicians, this law was grossly abused by the medical profession. But what's interesting here is that virtually all of the abortions that were sought for these reasons, for this reason, and almost every abortion that was approved for this reason. So I would say that the physicians who were encountering women who wanted abortions for mental health reasons were in effect just rubber stamping them. I don't think this was the intention of the legislature that passed the law. I think the legislators felt that this might have represented some type of a reasonable compromise between the older California law, which allowed abortions only to save the life of the mother, and this law. But this was not decidedly what turned out to be the practice in California. But the fact that so many women were authorized to have abortion under this narrow standard, supposedly narrow standard, shows that a mental health exception cannot be narrowly drafted. It's going to be abused. Well, the background to this legislation is the American Law Institute's Model Penal Code, which was formulated in the early 1960s as a model penal code for states to consider enacting, either entirely or parts of. The American Law Institute was very influential, has been very influential in drafting model laws on a wide variety of subjects in the United States. So this was picked up by a number of states, 13 states, including California, enacted one form or another of this law between 1967 and 1972. In fact, one of these laws, the one from Georgia, was the one the Supreme Court struck down in Doe v. Bolton, which was the companion case to Roe versus Wade in 1973. For the most part, these laws had similar exceptions. California, as I said, did not include a genetic anomaly exception, but basically they were laws that allowed abortions to preserve the woman's life, physical or mental health, and in cases where the pregnancy resulted from rape or incest. Now, the easiest pigeonhole in which to find an abortion reason would, of course, be mental health. And California probably knew that, and that's why, unlike all these other states, they attempted to restrict the scope of that exception. But as I've explained in the experience in California in 1970, from those statistics, that was unsuccessful. A mental health exception is inherently manipulable and cannot be contained. For any reason, regardless of what the reason was, mental health, physical health, whatever it was, it had to be reviewed by a panel of physicians. It had to be at least 2 physicians if the abortion was performed before the 13th week of pregnancy, and at least 3 if it was performed after the 13th week. The law at that time did not allow abortions for any reason after the 20th week. And the decision of the doctors had to be unanimous. If it was 2 doctors, it had to be unanimous. If it was 3, it had to be unanimous. So a woman seeking an abortion for a mental health reason had to convince 2 or possibly 3 doctors, depending upon her stage of pregnancy, that she was a danger to herself or to others or to the property of others, or that she was somehow in need of supervision or restraint, which again is the definition, the standard used for civil commitment. And despite that narrow definition, as again we've said, over 60,000 abortions in 1970 were performed for that reason, were performed and authorized for that reason. No, the effect of the decision, the name of the case is People versus Barksdale. The effect of the decision was to make abortions legal for any reason before the 20th week of pregnancy. And of course, the overwhelming majority of abortions, probably 98-99% of abortions, are performed before the 20th week. So between the time the Barksdale case was decided in 1972 and Roe, which was January of 1973, there were in effect no restrictions on abortions prior to the 20th week in California. That's how it turned out in California, and I feel that that would be the way it would turn out anywhere, because the whole concept of mental health is rather elusive. It doesn't present the same type of issues as perhaps a physical health exception or other exceptions, and it was clearly manipulated by the medical profession in California. This may not have been the intention of the drafters of the legislation, the actual legislators who voted for it. They may have felt these are narrow exceptions, but in reality they were grossly abused. In 1971, 2 years before Roe was decided, the United States Supreme Court had to interpret language in the District of Columbia abortion statute. The District of Columbia, of course, is Washington, D.C. It's not a state, it's a federal enclave. This is a law that was originally amended in 1901 to include a health exception. Before that, it was just life. In 1971, the Supreme Court was asked to interpret, what does that word health mean? Because the statute itself did not define it. And the court said, well, we think this includes psychological as well as physical factors. Under modern usage, health normally includes psychological or emotional factors as well as physical ones. Well, this, of course, meant that an abortion could be done for virtually any reason under the D.C. law. Now, slightly less than 2 years later, the Supreme Court decided Roe v. Wade and Doe v. Bolton. Roe v. Wade struck down the Texas abortion statutes, which allowed abortion only to save the life of the mother, and Doe v. Bolton addressed the Georgia statute, which was similar to the California statute. It allowed abortion for reasons of physical or mental health, the life of the mother, rape, incest, and genetic deformity. In that case, the court said even that law was unconstitutional because it did not allow abortions for basically any reason before viability. But what's interesting about the Doe v. Bolton case is they had to decide, when is an abortion necessary? What does that mean to say an abortion is necessary? And in Bolton, they looked back to their earlier decision in Viewage, and they said, well, we believe that that's a judgment that has to be left up to the doctor, and the doctor can take into account all factors physical, psychological, emotional, the woman's age, the size of her family, anything that could possibly relate to her health, very broadly understood. All these things could be taken into account in determining whether or not an abortion is necessary. Now, given that very broad language, I think it's easy to conclude that a health exception to an abortion law, certainly one without any attempt to define health, is completely open-ended, because it's always possible to find a health reason in some extended sense that would, quote, justify, unquote, an abortion. Well, there's a tremendous amount of interest in regulating abortion at the state level. This obviously has to be done within the limits that are placed on the states by our Constitution as interpreted by our United States Supreme Court. But states have enacted laws requiring parental notice, parental consent, short waiting periods. They've limited the use of public funds to be used for abortions. They have adopted regulations that affect clinics where abortions are performed. There's a broad range of legislation that states have enacted and are considering enacted that would regulate abortion. However, the perspective that one has to keep in mind is that's all in the context of a legal regime where abortions may be performed for any reason at all, before viability, and for virtually any reason after viability. So although the states may regulate abortion in various ways, they cannot actually reach out and decide that a woman cannot have an abortion. The authority is regulatory, not prohibitory. A mental health exception, no matter how rigorously and narrowly it might be defined by the Irish Parliament, is still potentially subject to abuse and constituting, in effect, an open door to abortion, depending upon how that language is construed by the Irish courts. That's certainly been the issue that we've confronted here. California is a striking example of that, where even in the absence of any court ruling, the law was clearly being manipulated and ignored by physicians in California. So even if you were to draft a mental health exception that would allow abortions, even in a narrow category of saying, well, the woman is threatening to commit suicide. And of course, people do threaten to commit suicide, often without having any intention of following through on that. And that can be very manipulable or manipulating behavior. But apart from that, even if you try and narrow it, there will always be some physician who will accept that at face value. And then as that becomes known, any woman, any pregnant woman who wants to get an abortion can simply say, well, this is legal if I go and tell my physician or a physician who's willing to do the abortion that if I don't have an abortion, I'm going to kill myself. And let me add here that no one that I know of regards abortion as a cure for a mental health problem. It's not a cure for a mental health problem. In fact, can lead to some mental health problems. But that's an aside. The lesson to be learned here is that mental health exceptions, no matter how carefully drafted, can be and will be abused by the medical profession and persons seeking abortions.